Hello, my name is Shafiq, and I'll be discussing the existing laws, regulation, and policies in regards to the disciplinary control over errant medical professional simulation. The main reference I'll be using is the Journal regarding the Reformation of Medical Disciplinary Proceedings Post-Medical Act 1971. Within this, we'll look into the main governing legislation. So among them is divided into three. Firstly is the Medical Act 1971, where the primary legislation regulating medical practitioners in Malaysia. Then there's the Medical Amendment Act 2012, which helps amend any of the medical flaws in the Medical Act 1971. So it improves disciplinary mechanisms and also regulatory powers while removing all the previous flaws that it had in the old act. Finally, there's also the Medical Regulation 2017. This one lays down the detailed procedures for disciplinary investigations and hearings. Next, we looked into what are the regulatory authorities. In Malaysia, the main regulatory authority is the Malaysian Medical Council, known as the MMC. It is a statutory body responsible for registration and licensing of doctors, regulation of professional conduct, and investigation and disciplinary action against practitioners. There's also in regards to the disciplinary framework. So in terms of disciplinary framework, how does disciplinary action begin? So the question is answered simply by a complaint is submitted to the MMC, which they will then begin a disciplinary proceeding. And throughout this disciplinary proceeding, investigation conducted through the disciplinary panel includes Preliminary Investigation Committee, the PIC, and disciplinary board. So to summarize the same process, a formal written complaint is submitted to the MMC, and this can be made by entirely anyone, including patients, family members, employers, or other parties who believe that a doctor has breached professional ethical standards. When a complaint is received, it's reviewed by the PIC, Preliminary Investigation Committee, which conducts an initial assessment of the complaint and determines whether there is sufficient evidence to proceed with a formal disciplinary inquiry. And if there is a lack of, it will be dismissed at any point. But if there is reasonable grounds, the case will be referred to the disciplinary board, and the disciplinary board will then commence a formal inquiry by examining the available evidence, hearing witness testimony, and so on. So then, the practitioner is also given an opportunity to respond to the allegation and defend their actions. After inquiry is completed, the findings and recommendations are submitted to the MMC, in which the decisions or whether the disciplinary action should be taken is decided. And if the practitioner is dissatisfied, they can appeal it further. Well, what are the general types of misconduct disciplinary actions? This can be divided into two, which is the first, professional misconduct, Section 29 of Medical Act 1971, which lists as you can see here. But to be fair, not really two, but like five. So these are the five ones. You divide it into two main ones under the Section 29, which is they have jurisdiction over all registered persons under the Act, and secondly, what are the specific offences. But we'll look into what are the punishments, which can be seen here under Section 30, where the MMC may strike off any practitioner from register, suspend their medical license, issue reprimands, impose conditions and restriction on practice, or require further training and rehabilitation, as well as impose fines. So these are the actions be taken. And that's all for me. I'll be passing it to the next colleague who will discuss their topic. Thank you.
Hi, I'm Farah Najibah, and I will continue the presentation and discuss the current unresolved issues arising with disciplinary control over errant medical professionals. Now, the issues that will be highlighted in this presentation are as follows. Now, as mentioned in the first part of the presentation, Medical Act 2012 amendment has introduced the disciplinary panel, which consists of PIC and the DB. Now, pre-amendment, any complaint received by the Council will be directed to PIC for prelim investigation before being forwarded back to the Council for inquiry and decision. With new amendment, DB now are responsible for conducting inquiry instead of the councils. DB will call medical professionals for defense and will decide whether to dismiss the case or forward it back to the council with their reports and recommendation. The councils are the one responsible to decide on the final verdicts. This added multi-layer process, which seems more like relegate the council function for inquiry to DP, added layers to the procedure and become more time-consuming. So complex and lengthy process will lead to slow proceedings, causing delays in action, which then leave the doctors in limbo and delaying justice for patients. Next is low investigation rate of complaints. Reports suggest that there is less than 1% of thousands of complaints results in formal disciplinary action. With low investigation rate lead to low punishment rate. Then question raised whether the system is effective enough and whether the errand doctors are sufficiently held accountable for their mistake. All these questions result in low public confidence toward the entire system. Next issue is the lack of procedural transparency. This can be discussed through several aspects. First, the comprehensive report and written judgment are not available to the public. Now, even though MMC do publish the name of errand doctors with the summary of case and the action taken, there is no detail on how they achieved to the final verdicts. So this makes it difficult to evaluate the efficiency and consistency of the system. Another aspect is in regards to the unpublished name of errand doctors who is under interim suspension or restriction order, which was introduced under 2012 amendment. DB may issue the order before the conclusion of hearing if they feel the state doctor are a threat to a public safety. However, there are no requirement to publish the name of the state doctors. This lack of transparency will lead to reduced public trust toward the healthcare system, and they cannot make informed decisions about the doctors they choose for treatment. For doctors' part, it concerns in regards to the accountability and prevent other doctors to learn from past cases. And even worse, if the doctors are not afraid of making mistakes when disciplinary action are not disclosed to the public. Next is the limited jurisdiction of MMC. As the power vested by the Medical Act 1971, MMC may conduct a medical disciplinary proceeding involving medical professionals focusing on serious professional misconduct rather than medical negligence, which is usually left to civil court. However, there are no clear distinction between the two, and patients may be confused about where to file complaints, which then leave patients disappointed and claim dismissed by the council. Another issue is that MMC only has disciplinary jurisdiction over registered medical professionals. They don't have the authority to take action against unregistered or bogus doctor, which is usually left to the police. Again, this will confuse patients. It makes it difficult to file complaints against unregistered doctors, and the state doctor can continue providing service without fear of being subjected to disciplinary action. This creates gaps in accountability and patient protection. Next is the public perception towards MMC as protecting one's profession. Several issues that may lead to the perception are first, when the complaints are made, burden of proof lies heavily on the complainant, and they often find it difficult to obtain medical records from healthcare institutions and expert medical witness to testify against colleagues. Another aspect is the limited public representation in disciplinary proceedings. Now, with new amendment, one non-medical representative may be included in DP. However, final verdict still relies fully on the council, which dominated by the medical professions. This may lead to a possible conflict of interest in the proceedings and reduce public trust in the impartiality of the process. Another interesting aspect that can be highlighted is the patient's limited role in disciplinary appeals, where only doctors can appeal the decision of disciplinary proceedings to the court and left patients with no option. The next issue is the shift of liability from individuals to institution. Recent federal court decision in 2024 case established that private hospitals have a non-delegable duty of care which shift responsibility from individual doctors to institution. As the focus shifts, the involved doctor may not be held fully accountable for their misconduct and may continue practicing without proper sanction. This shift may also weaken the disciplinary control as the focus is now placed on institution responsibility rather than doctors' professionals' behavior. Final issue is the effect of disciplinary action on medical practice behavior. Now, while the disciplinary action towards errant medical professionals may bring justice to the patient and ensures other doctors to always comply with ethical and professional guidelines, it raises concerns regarding the potential negative impact which may influence the medical practice behavior. Study shows that doctors tend to exhibit avoidance behavior following the disciplinary action, where they become overly cautious in giving treatment and practice defensive medicine to avoid complaints and potential disciplinary action. Doctors may prioritize protecting themselves from complaints rather than focusing on optimal patient care. As a result, it may lead to inefficient practice and compromise the overall quality of care. All the issues highlighted in this presentation pose challenges that may affect the effectiveness of the system. These issues should be addressed to ensure that the balance is struck between the interests of the public and the rights of medical practitioners. Next presenter will discuss on the practical solution to resolve the issues listed. Thank you.
A very good day to Dr. Wilson and my fellow colleagues. My name is Siti Raihan. I will be talking regarding the possible solutions for disciplinary control over errant medical practitioners. On this slide, I will further elaborate regarding professional accountability. What is all professional medical accountability is all about? It refers to the obligations of medical practitioners to take responsibility for their professional conduct, especially for their clinical decisions and also quality of care they provide to patients. This to ensure that the doctors will practice ethically, competently, and also in accordance with established medical standards and also legal requirements. This is where the Code of Professional Conduct takes place. It is issued under Medical Act 1971 for the Malaysian medical health professionals to conduct themselves in the service. I would like to highlight regarding the core elements of this Code of Professional Conduct. The firstly is regarding safeguarding the patients to ensure health and also welfare of the patients under a doctor's care. Guiding doctors provide a framework for ethical and also professional conduct. Advertising, canvassing, and also related professional offences. Good medical practice and also confidentiality to ensure protection of patient info and also confidentiality of the medical records. Next, professional standards, setting benchmark competency, continuous professional development, and also quality assurance, which I will elaborate in the slides later. Conflicts of interest, addressing issues, conflict of interest that could compromise patient care, patient safety to protect patient through ethical conduct and also adherence to legal provisions and also guideline. CPG are provided by Academy of Medical of Malaysia, AMM. AMM provides comprehensive guidelines from various medical specialties. In the medical field, we have many departments such as ENT, ophthalmology, medical, surgical, and also etc. These guidelines define the role of specific diagnostic and also treatment modalities in diagnosis and also management of patient. It's recommendations that are based on evidence from rigorous systematic review and also synthesis of published medical literature. These guidelines are not fixed that must be followed, but are intended for healthcare professionals and providers to consider. They identify and also describe generally recommended courses of intervention that are not presented as a substitute for the advice of physician or other knowledgeable healthcare professional or provider. Basically, what we need is that for doctors to be safe, and we don't want harm for the patient. So clinical practice guideline acts as a guide for all the doctors to see what is the basic standard of care that is being proposed for the clinicians. But from the clinicians' point of view, also they need to base on their experience, their discussions with other colleagues in their field, and also that also takes into account. So there is no hard and fast rule in what is right, what is wrong. But the most important basic things is that you do no harm for the patient. We need a mechanism how to continuously monitor the doctors and also the staff. So MOH introduced credential and also privileging to ensure continuous mandatory training for medical professionals to maintain competence. CNP are meant for doctors, nurses, and also assistant medical officers, allied health professionals, and also primary care professionals. This CNP is renewed every 3 years based on CNP guideline. Continuous assessments are done by logbook procedures, supervision evaluations, and also clinical performance reviewed by the hospital credentialing committee. These are done at the hospital level to ensure the competency and also all the medical staff are continuously evaluated. Credential and privileging are important process that is being introduced by the MOH to ensure that doctors are qualified and competent to provide specific medical services. The objective to really make sure that patient safety and also management is the most important thing that being emphasized in the public health. Other purpose is for only to train the medical healthcare workers can perform specialized procedures. Thirdly is to catch where there is errant or incompetent practitioners. This is where the CNP can add to restrict and also can keep tab of the doctors who are errant, and we can retrain them to make sure that their competency is being upheld. As if now, CNP is only regulated in public hospital and also in the clinics. However, CNP has not been introduced in the public sector. So the reform that I suggest that this continuous mandatory training also should be extended to private healthcare professionals. The other reform that I suggest is that there should be a continuous assessment for senior professionals, including specialists and also department heads. Generally, it's understood that the extensive training and years of experience, these individuals are expected to maintain a high level of competency. That is the only way of disciplinary action by filing a complaint within to the MMC, which can take years to process. Additionally, junior doctors no channels to report about misconduct of their consultant because of the hierarchical structures in the hospital setting. The easiest way is to make anonymous complaint to CISPA, but there is no protection against whistleblowers in the MOH system. Other crucial to prevent errant doctors are continuous monitoring and also healthcare education development. Hospitals can introduce continuous ongoing education on also development through continuous clinical audit systems, where it regularly audits all the healthcare system and how the service is being brought about in the public healthcare and also in the private healthcare. Secondly is regular continuous professional development CPD requirements, and also training for continuous human development for healthcare workers in areas such as medical ethics, patient safety, and also communication. Even though it seems that the other two, like medical ethics and also communication, is very trivial, but actually is very important. How you communicate with your patients and also their relatives makes such an important role to make in the managing and also treating the patients. Continuous self-development through CME is a continuous medical education at the department and also hospital levels. CME implementation should be a key performance indicator for the HOD and also for the hospital directors. The hospital can encourage and give more money allocations to the department in the hospital to organize medical workshops at department, hospitals, and also state and national levels. This is where all the doctors sit together to exchange experience about their surgical procedures, about what is the medical advancement in medical fields. Firstly, I would like to talk about what is Hospital Disciplinary Panel. It's an internal body established within a hospital to investigate, to address complaints or misconduct involving the healthcare professionals. This consists of, the panel consists of senior medical officers such as specialists and consultants, hospital administrators, and also representatives from relevant departments. The function is to review allegations such as negligence, breach of professional conduct, unethical behavior, and also failure to follow hospital policies. There are a few reforms that I would like to suggest at the hospital level to curb errant doctors. Firstly, is to create channels for easier for patient and also relative complaint to reach the committee. When doctor complains against another colleague, they have a direct link to the hospital administrators, but the patients and their relatives doesn't have that privilege. Secondly, internal inquiry, external inquiry being performed, which already implemented in the system to investigate misconduct of any healthcare professionals, regardless of their medical position, more swiftly and also transparent. Thirdly, there should establish more medical legal unit in hospitals and also clinicals in Malaysia to evaluate and or the risk of medical litigation for potential cases and find ways to reduce the risk of escalation. Fourthly, that in the there is a usage of mediation as an alternative for dispute resolution method to help the patient and healthcare provider to reach mutual acceptable settlement without going to court. This can further reduce costs for the medical litigation and also reduce time. As we know, medical litigation to settle a certain case can take many years. There is a strong call for MOH to establish independent medical complaint tribunals. Despite the current reform, an amendment was made through Medical Regulation 2017 to grant independence and also impartiality to the MMC as a regulatory body that has been placed previously under the purview of Medical Practice Division, the MOH. However, even though the reform has been made, there is still many more reforms to be made because MMC records show fewer than 20 disciplinary cases per year, indicating that the procedural delays may be impeding effective disciplinary action. Certain figures show there's only 1% of the complaints being made to the MMC that has been resolved over a year. Addressing these delays is essential to restore confidence and also ensure timely response by the MMC. Faster complaint investigations under MMC should be adhered. Establish strict timeline for complaint investigations starting the date of the complaint until it reached to the disciplinary board within this MMC. MMC should create better policy and protections against whistleblowers for healthcare workers who report misconduct. MMC also should start using the digital platform to establish an intuitive and engaging system for medical practitioners and to empower them to report misconduct with ease. As I've already mentioned in the earlier slides, where there is barrier and also there's limitations for the junior doctors to complain regarding the misconduct of their consultants, specialists, or their hospital administrators. Publications of disciplinary decisions should be done in great details on MMC official website. This should include regarding facts of the case, findings, and penalties imposed to allow the public and also medical professionals to understand how the council enforce professional standard. This could act as also to give enforcement for transparency on the MMC disciplinary action. The recent decision to include non-medical individuals in the disciplinary panel and also disciplinary board of a long-standing institution which traditionally focus on its own business matters, meaning that doctors in their own circle, which they already allow that non medical professionals such as judges and lawyers should be applauded. MMC should also publish annual reports on the disciplinary cases, investigation conducted, and also sanction imposed, as we can see how many cases that they can solve in a year. In the case of Dr. Fugi versus MMC, underscores the critical concern regarding fairness efficacy of the disciplinary proceedings by MMC. These procedures of disciplinary action investigation are often lengthy and complex. They may subject to legal challenges, potential resulting in delays and also resolution of complaint against medical practitioners. This is where the idea of independent medical tribunal should be introduced. What is independent medical tribunal is a separate adjudicatory body to establish. The tribunal would be specialized in professional misconduct cases and help speed up hearings while maintaining fairness. The reforms that I want to suggest is that the third layer, introductions of independent members representing public interest, such as expertise from teacher, a retired government government services. This should be appointed in the independent medical tribunal to protect the public interest. Other panels should come from, of course, from the senior medical practitioners with relevant expertise, or legal professional judges and also lawyers.
Hi, I'm Dr. Amy. I will continue this video presentation Part D on the reform to the laws, regulation, and or policies to improve the disciplinary control over errant medical professionals. I have identified 5 possible reforms needed to likely improve these issues, as was highlighted, as was mentioned by my colleague Dr. Farah. The first reform is to amend the Medical Act 1971 to include a provision on enforcement. Section 29 and Section 30 gives power to the Council to exercise disciplinary control over medical professionals through disciplinary proceedings, as was presented earlier by my colleague Encik Shafiq. There is also another general section on fraudulent registration and offences with a list of actions that is considered offences under the statute. However, there is no provision on this Act for enforcement mechanism or provide any investigative powers to authorized officers. As was highlighted by my other colleague, Dr. Farah, current unresolved issues is the complexity of the disciplinary action with its multiple layers and stages. The further lack on the authorized officer to investigate alleged misconduct has further delayed these disciplinary proceedings. A statutory investigative power allows an authorized officer to enter the premises, obtain evidence, so generally speeding up the investigation process. Although there is a provision on offences in Section 32, there is no enforcement mechanism to allow medical counsel to investigate, leaving any breach of conduct under this section to other law enforcement agencies, which complicates and making disciplinary control inefficient. Recent healthcare statutes in Malaysia has already incorporated provisions of enforcement for a better governance in their statutes. For example, Dental Act 2018, where they have incorporated Section 70 to 77 on enforcement and authorized officers. In another quite fairly recent statute, 2016, the Traditional and Complementary Medicine Act 2016, where there is a specific provision on enforcement, Section 48 to 59. So the next reform for the Medical Act in 1971 is to strengthen and broaden the scope of fitness to practice framework. The power of counsel to exercise fitness to practice is under the Section 19 and 24, where their jurisdiction is to mainly restrict registration and to remove or suspend medical practitioners after finding that there is not fit to practice. So expanding the scope of fitness to practice to include not only punitive measure but to also include the structured remedial mechanism aimed at supporting professional rehabilitation This may include the provision enabling the council to require a mandatory remedial training, supervised clinical practice, a competency assessment, and also a review of medical professional after disciplinary suspension. This broader scope of power for the fitness to practice allow regulators to intervene in cases involving a declining competence. So this shifts the disciplinary system towards a more preventive and patient safety oriented regulatory. This comparison for broader scope of fitness to practice was made with the UK Medical Act 1983, where the authoritative power to govern medical professionals is given to General Medical Council (GMC). The GMC has the authority to refer cases to medical practitioner tribunal services for formal education under the fitness to practice. The next reform that may be beneficial to improve disciplinary control is to amend the Private Healthcare Facilities and Services Act 1998. This act governs private facilities and services, while Medical Act governs the medical professional itself providing the services. And interagencies better coordination is needed between the licensing authorities and the professional regulators. The information sharing between these two agencies will provide a more effective oversight on the medical practitioners and ensure that the regulatory actions are consistent within the healthcare system. However, under the Section 112 of the Act 8586, Furnishing of Information, it is prohibited for the officers to share for data sharing to the third party. It is difficult for the coordination if there is a prohibited data sharing internally between healthcare agencies. A proposed amendment of the Act is to allow data sharing. This is, for example, like a recently passed bill in January 2036 by Singapore on the Health Information Act 2036. So this Act specifies what the restriction of data and what allows data sharing between the government agencies. Another reform that is needed to set the statutory timelines for disciplinary proceedings with clear timeline for each stages in the form of guidelines. Along with adding the provision of authorized officer, this will make the disciplinary investigation proceeding more effective. Last reform that may be effective to improve the disciplinary control is by establishing an independent medical tribunal that liaises with the court system in Malaysia. Medical Regulation in 2017 amendment, Section 34 of the disciplinary panels, members are elected by the councils that consisted of medical members and one non-specified person. So this creates the perception of impartiality and the perception of doctors regulating themselves. Looking at the UK GMC, there is a medical practitioners tribunal services established under the council, but members are from the legal professions to give some information about the legal part of this system, a medical professional to give a medical opinion, and also a lay person to understand, to represent the public. This provides an independent adjudication to the disciplinary control. The council, after investigation under fitness to practice, may refer cases to these medical practitioners tribunal services for further and independent adjudication, demonstrating a more comprehensive and transparent approach to professional discipline. With this, I will end my presentation and pass the next presentation to my colleague, Dr. Atika. Thank you.
Moving on to the likelihood that these reforms will be made, we look at moderate likelihood of these reforms because of recent legislative reforms make further reform possible. So recent healthcare statutes in Malaysia have already incorporated similar provisions to strengthen governance within their respective regulatory frameworks. For example, Section 70 to 77 of Part 7 of the Dental Act 2018 and Sections 48 to 59 of Part 9 of the Traditional and Complementary Medicine Act 2016 demonstrate the government's willingness to modernize healthcare legislation. In light of these developments, further reforms to the Medical Act 1971, such as introducing statutory investigative powers and strengthening disciplinary procedures, appear realistically achievable. And we also have moderate likelihood because of growing public demand for accountability. Patients today are increasingly aware of their rights and expect greater transparency when medical errors or professional misconduct occur. As a result, regulators such as the MMC are under growing pressure to strengthen oversight, making reforms to disciplinary mechanisms more likely. High-profile cases of medical negligence often attract significant media attention and public scrutiny, which further intensifies calls for accountability. Reforms that promote transparency, such as statutory timelines for disciplinary proceedings and improved information disclosure, are therefore more likely to be supported. By enabling regulators to investigate potential misconduct more effectively and proactively, such reforms would strengthen disciplinary control over medical practitioners while also supporting the broader objective of safeguarding patient safety and maintaining public confidence in the medical profession. And we also have moderate likelihood in improving transparency through information disclosure. Reforms requiring healthcare facilities to provide information during investigations under the Private Healthcare Facilities and Services Act 1998 are relatively straightforward to be implemented. These amendments are largely technical in nature and primarily aim to improve cooperation between healthcare institutions and regulatory authorities. As such, they are generally more feasible than larger structural reforms within the disciplinary system. And we have lower likelihood of expanding investigative powers or creating an independent tribunal. The introduction of clear statutory timelines for each stage of disciplinary proceedings, as well as the proposed establishment of an independent medical tribunal, may face resistance from members of the medical profession. Professional self-regulation has traditionally been valued within the medical field, and reforms that expand investigative powers or introduce external oversight may perceive as limiting professional autonomy. As a result, these proposals could slow the adoption of such reforms. In addition, the creation of an independent tribunal or the expansion of the investigative powers may also face legal challenges from professionals who argue that these measures violate their professional rights. Which such challenges could delay implementation. Carefully drafted legislation and appropriate safeguards could address these concerns and allow the reforms to be implemented in the medium to long term. And we have gradual likelihood of structural reforms, as introducing statutory timelines for disciplinary proceedings or establishing an independent medical tribunal would require significant legislative amendments, administrative resources, and sustained political commitment. As such, the implementation of these reforms may occur gradually rather than immediately. Nevertheless, Malaysia is often compared with jurisdictions such as the United Kingdom, Australia, and Singapore in terms of professional regulation and healthcare governance. Adopting reforms such as independent tribunals and structured fitness to practice frameworks would therefore enhance Malaysia's professional credibility and may increase pressure to introduce similar measures. However, healthcare policy must also compete with other national priorities, including workforce shortages and public health challenges. Consequently, while reforms aimed at strengthening disciplinary control may receive support, their implementation will likely depend on whether the government prioritizes restoring public confidence in the healthcare system.